Hi, I'm Darcel Lobo, and I own Dow Law Firm here in the Seattle area. And today we're going to talk about deeds. A big part of my practice in my firm is various residential real estate matters. And so I handle things in for sale by owner transactions where a home is being sold without the use of a real estate agent. I do a lot of title work, clearing up title issues on a home. I do real estate work helping clients, maybe who are investors with forming their LLCs and holding that real estate. So a kind of a wide array of different real estate things that I handle only residentially. And a lot of things that I handle in my real estate practice have to do with deeds. And so I thought today let's talk about different types of deeds. And I'm going to talk about the 5 types of deeds that I come in contact with most commonly, the ones that you've probably heard of, or maybe a few of them you've heard of and don't understand like what the differences are, when would you use one versus the other. So we're going to go over those 5 deeds. And the 5 deeds we're going to cover today are statutory warranty deeds, bargain and sale deeds, quit claim deeds, QUIT, not QUICK, a common misconception, a transfer on death deed, and a personal representative deed. So if you want to know more about any of those deeds, you're in the right place. So let's start with a statutory warranty deed. This type of deed gives you the highest form of protection as a buyer. This is the type of deed you're generally going to see when you are purchasing a home, is that the seller is going to give you at closing, so through escrow, right, they're going to sign a statutory warranty deed that transfers title to you as the new owner of the property, but also, as the name implies, it has warranties under a statute in Washington state. And so there are warranties that are implied and explicit in that deed, assuring you that what I tell you that I am transferring to you is actually what you're receiving. Because there are warranties and assurances that come with that title transfer, whenever you are buying a home, and especially if you are financing the home, the lender is going to require this, you will have title insurance to insure that title of the property. So if you ever had a dispute down the road in regards to the title of your ownership of your property, the legal description and boundaries, or any issues with title down the road, that insurance and that warranty deed you receive are what you as the buyer are going to be looking to protect you and to cover you. So when you are selling the property as the seller, you are delivering to the buyer a statutory warranty deed that the escrow company will prepare for you to sign as the seller at closing, delivering that title to the buyer. So you're giving them more assurances, more warranties as the seller when you're delivering that type of title to the buyer. And the reason why you are giving that type of title is because you are selling this to them, right? They are paying a purchase price to receive that property. So you are going to give them that assurances that what you say you're giving them is actually what you're giving them. But again, there is also title insurance to also ensure that transfer as well. Okay, so that is a statutory warranty deed. So now let's turn to a bargain and sale deed. I don't see these a lot. Most commonly, I see a bargain and sale deed when you are buying a home from a bank. So if the bank has foreclosed on the home and has received that home back from the prior homeowner, there was a default, the lender foreclosed, now the bank has put the home on the market for sale. When you buy a home from a bank, they are going to give you a bargain and sale deed. It does not have the same assurances and warranties that you would receive in a statutory warranty deed. Now, why is this? This is because when the bank acquires the home, they have never usually, they've never actually possessed the home. No one's lived in the home during the bank's ownership, right? The bank foreclosed, turned it around, and then sold it on the market to someone else. So the bargain and sale deed is not going to have the same warranties and assurances that you have with a statutory warranty deed. The bargain and sale deed is limited in what you receive in that deed, what assurances you receive. Now, as the buyer, assuming you are using financing to buy that home from the bank that's selling it, your lender is still going to require title insurance. You can still get title insurance on that purchase of that property to also ensure that you have proper title to that property. And so you'll want to discuss that with the title and escrow company when you're buying the home, but you can still acquire that even though you're getting a bargain and sale deed. That's usually the only time that I see a bargain and sale deed specifically. It could be used in other situations as well. That's just where I usually see it, is when you are buying a home from a bank, and most commonly that's because the bank has foreclosed on that home previously. All right, the next type of deed, a quit claim deed, QUIT. The one that I see the most, the one that I deal with the most. With a quit claim deed, you are, as the seller or as the grantor, you are not giving all the warranties and assurances that you would deliver in a statutory warranty deed. So usually if you are gifting real estate to someone, let's say you're gifting it to your child or to anyone else, you're not going to give all the warranties and assurances in a statutory warranty deed. The quit claim deed says, you are going to receive whatever interest I have in the property. So whatever interest you have as the grantor or the giver of the property, you're giving whatever you have. You're not guaranteeing anything. You're not warranting anything. So that's most commonly where you see a quit claim deed. It's with a gift because you're not giving those guarantees and assurances. We also use a quit claim deed when we're transferring your real estate into your trust for estate planning purposes. Let's say you have a revocable living trust. We will use a quit claim deed to transfer your property from you individually into your newly formed revocable living trust. Also, if you have an LLC, let's say you have investment properties and you have an LLC that you want to transfer that real estate into, we would use a quit claim deed to transfer that real estate out of your individual name into the LLC name. One caveat with that, if by any chance you are looking at forming an LLC to acquire real estate, to hold real estate for your investment, and you are doing so because you want the protection that an LLC gives, please do not put multiple properties into the one LLC. I tell my clients you should have each property should have its own LLC. Don't start mixing all your properties into one LLC. We don't have time right now to go into why, but I will. I think I've done a few videos on this. I'll link those below, and if I haven't, I will do one soon. But each property should have its own LLC. But we're getting off on a tangent. A quit claim deed is a limited type of deed that you're saying, whatever interest I have, I'm giving it to you. I'm not giving you any guarantees. I'm not giving you any warranties, no assurances. You get what I get, and that's it. Okay, that's the most common type of deed that our office is hired to prepare, is a quit claim deed for a wide array of purposes, but that's the one that we see the most. All right, a transfer on death deed. This is a big one. This is one that I see more and more. You know, Washington State, I forget when it first passed. I think we've had it for at least 10 years in our state. A transfer on death deed is just naming someone as a beneficiary to your real estate. So, as the name implies, transfer on death deed, you're not transferring any interest right now, but you are naming someone as a beneficiary so that upon your passing, that property goes directly to them. And so we do, have to prepare this deed document that says, you know, I own this property, but upon my passing, it's going to go to such and such person. It could be a child, assuming they're over 18. They have to be over 18. But you can name more than one person. If you have 3 children and you want it to go to the 3 of them, you can use a transfer on death deed to name the 3 of them to be the co-owners of that property. The only thing to know is that we have to prepare that now and record that now with the county. So it is public record. So I tell my clients, if the person you're naming as beneficiary has any kind of debt concerns, if they have a tax lien, child support lien, any kind of liens against them, judgments against them, any of those creditors can see that that person is going to receive that real estate, and that judgment or lien can attach immediately to that real estate. So that's one thing to keep in mind with a transfer on death deed. But otherwise, it's a great way to name a beneficiary for that property to pass to someone immediately upon your passing. And the last deed to talk about is a personal representative's deed. This is similar to a quitclaim deed, but you use it in a probate. Okay, so someone's passed away, a probate is opened, there's real estate that the probate estate is going to sell. The probate estate does not give a statutory warranty deed to that buyer because the estate has no knowledge about the home. And that's also why the probate estate is exempt from the seller disclosure form, from the Form 17. They do not have to provide a Form 17 seller disclosure form because they don't have any firsthand knowledge about the condition of the home. The decedent has passed away, who lived in the home presumably. So with a probate estate selling a home, they will do a personal representative's deed that says the buyer receives whatever interest the estate has in the property. You're not going to have the same warranties, guarantees, assurances that you would get in a statutory warranty deed because the probate estate is not in a place to be able to give you those types of warranties. Again, you can still, as a buyer, get title insurance for that purchase, but just know that you're not going to receive a statutory warranty deed when you buy the home from a probate estate. And if you are the executor of a probate estate, know that you do not have to deliver a statutory warranty deed. Your contract with that buyer should state that the conveyance of the property will be by personal representative's deed and not by a statutory warranty deed. And there's some other provisions that should be in that contract as well for a probate estate and selling a home, but that's a different video for a different day, not today. So I hope this is helpful. There's kind of the top 5 deeds that we handle in our office, that we deal with and that we see on a regular basis. So I hope this helps. And if you need any help with a deed or real estate matter, give our office a call or send us a text. Our number is 206-408-8158. But again, I'm only licensed in Washington State. So if you're not in Washington State, I would love to help you, but I cannot. I would suggest you contact your county bar or your state bar, wherever you live, to seek a referral for an attorney who can help you because we can only help clients in Washington State. And our website is dallawfirm.com, DALLAWFIRM. All right, .com. Thank you.